Welcome back, everybody. Welcome back. Dark Angel, part two. One country, two jurisdictions. Uh, I want to take and elaborate back to video one, part one of one country, two jurisdictions. I want to elaborate on some of the things that were said through that video. As we were talking about before, we were mentioning about how the loopholes that the police officers use. So, if you remember in that first video, I was mentioning to you guys about how the officers can they have statutes in place to where they can lie to you, and as long as they're not promising you anything, that they have the right to lie to you, as they put it. Let them put it. Let them tell it. So, they also, what a lot of people don't realize is they have a right to entrap you. They've made entrapment legal now, so there's that, so always remember that in speaking with law enforcement, the best thing to do is shut up some more, keep shutting up, Fifth Amendment, one of the other loopholes that they use, along with probable cause, discretion, is suspicion. So they use these are loopholes. These are loophole terms that gets an officer around trumping on your rights through some type of legality. So you have to keep this in mind. Now, never in life has suspicion ever been a crime. Never in life has probable cause been a crime either. So I wanted to elaborate back onto the fact that there was actually a case. So let's say, for instance, you get pulled over and an officer asks you to search your car. Okay, now you got to keep in mind, remember what I was telling you back in videos prior to this about how law enforcement and the courts manipulate you by the use of words. Okay, well, the Supreme Court admitted back in a case called Carroll versus somebody. I don't remember right off the top of my head, but I will look it up and locate that. In the Carroll case, when an officer asks for consent and you say no, the police can legally still get around that and still be able to search your automobile. However, in 2018, United States versus Williams, it was case number 16. Let me look real quick. Hang on one second. It was 1635-47, 2018, U.S. Appellate Court, Lexus 21304, Third Circuit Appeal, August 1st, 2018. United States versus Williams. And let's say, for instance, the officer asks if he can search your car and you give him consent. Okay, he could be right in the middle of search. It doesn't even matter. As long as you're filming the whole thing, make sure you film it, because the most important part is to film it. You can revoke consent at your will. Look that case up that I just told you, Williams, United States versus Williams, and look for that 16 number case. It's 2018, that's the year of the case. It's a 16, like I said, 1635-47. There it is, 1635-47. Look it up and check it out. You can revoke consent. Now, if you say no, the police can still get around the no. Okay? Remember what I was telling you. It's all about word manipulation. So, if you revoke They have to stop. Period. I've seen this in action. I've seen someone use it. Uh, I was actually watching a channel, Delete Laws. I don't know if you guys heard of this guy or not, but Delete Laws. He actually, he does a little bit more than just going around, First Amendment auditor and stuff. He does a little bit more than what is actually being told about him. Uh, but on the same strength, he was the one that actually put me down to that law, as he pulled up on a traffic stop, and he told the driver what to say to the cop. As the cop, he consented to search the driver's car, and the driver was standing off to the side. So Delete Laws told the driver, enforce this with authority, say it out loud, you revoke consent to search, and the officer has to stop searching. So the driver said it, and the officer was like, huh, what do you mean? And the driver repeated it and told him, I revoke consent. Well, in that particular episode, the officer did stop, did immediately stop the search. Now, this subjects an officer to deprivation of rights if he continues to search once you've revoked that consent. Okay, so that's just for your knowledge, FYI. So anyway, I want to get into some other things, because what I want to do is I want to elaborate back on video 1 for a minute before we continue on with the readings from for part 2, because I want to make sure that you guys know and understand. This is what I'm getting ready to read to you. These are Supreme Court cases, okay, in reference to the United States government. Okay, but the very first case I want to read is Shapiro versus Thompson, 394 U.S. 618, April 21st, 1969. Further, the right to travel by private conveyance for private purposes upon the common way cannot be infringed. No license or permission is required for travel, when such travel is not for the purpose of commercial profit or gain on the open highways operating under license in commerce. The rights of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of the government. There's also a supporting case, Sinez versus Roe. That's a 1999 supporting case. Okay, so Sinez and Roe is a 1999 case that supports this 1969 case. Moving forward, so City of Dallas versus Mitchell, 245 Southwest 944. To take away all remedy for the enforcement of a right is to take away the right itself, but that is not within the power of the state. So, moving. Waivers of Poindexter versus Greenhow, 114 U.S. 270, 303, 1885. Brady versus U.S. 397 U.S. 742, 748, 1970. Here's two cases that, look at this, they're damn near centuries apart. And they say waivers of the constitutional rights not only must be voluntary, they must be knowingly and intelligent acts done with sufficient awareness. Okay, so Cooper versus Aaron. Cooper versus Aaron, 358 U.S. 178, Supreme Court, 1401, 1958. The corporation is an artificial entity. Now, here you go. Remember in the first video, I read you almost the same passage from a case that was surrendered back in the 1700s and the 1800s in part 1 of this little series. So here's one in 1958 that's come years up and it says the corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excess cannot be imposed. Okay? Montgomery versus State, 55, Florida, 97, 45 South, 879. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons, the imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. With the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. Okay, so here you go. Here's what y'all want to know. This is what they don't want you to know. SCR 1795, Penhallow versus Dunn's Administrators, 3 U.S. 54. The contracts between them involve U.S. citizens which are also deemed as corporate entities. Therefore, the U.S. citizens residing in one of the states of the Union are classified as, are you listening to this? U.S. citizens are classified as property and franchises of the federal government as an individual entity. How'd that happen? As I said, one country, two jurisdictions. A party cannot be bound by contracts that he has not made or authorized. Free consent is an indispensable element in making valid contracts. Alexander versus Bosworth, 1915. Now, here's the case. This case here has been in front of, I'm quite sure you guys have heard of it, Hale versus Hinkle, 201 U.S. 43 at 89. 1906 is when this case was done, but this case has been up in front of the Supreme Court over 1,600 times. And 1,600 times the case has never been overruled. Okay? Never been overruled, never been superseded. And it reads as follows. Hale versus Hinkle was decided by the United States Supreme Court in 1906. The opinion of the court states that the individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no duty to the state since he receives nothing therefrom. Beyond the protection of his life and property, his rights are such as existed by the law of the land, common law, long antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. And like I said, that case, 1,600 times it's been brought before the Supreme Court. And it's crazy that this case has been brought up that many times, and at no given time has it ever been overturned. At no given time has it ever been superseded by anything. So, there's that, I mean, that speaks precedence. That speaks volumes. Pontius versus McLean in 113 California 452, the word operator. Okay, now, because I've had a lot of people always tell me, well, the Supreme Court has never defined, certain definitions and words. Well, here you go, because I'm getting ready to hit you in the head with your favorite case that y'all love. Actually, I'm gonna skip Pontius for a minute, and I'm gonna back up one, and I'm gonna go to your favorite case, you haters. Hendricks versus Maryland, the one that you guys keep citing all the time, that you fail to see the part of the case that actually matters. Hendricks versus Maryland, South Carolina Reporters, RD 610-625-1914, which was a case that actually was settled in 1915, was stated that by the Supreme Court, one who drives an automobile is an operator within the meaning of the Motor Vehicle Act. Just saying. People versus Horton, 14 Cal, Appellant 3rd, 667, 1971. A U.S. citizen upon leaving the District of Columbia becomes involved in interstate commerce as a resident does not have the common law right to travel of a citizen of one of several states. Now, here you go, right here. Barbarian versus Lucier, I think I've read this and covered this in part 1. The right of the citizen to drive on the public street with freedom from police interference unless he is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right which must be protected by the courts. And if you noticed in that reading, one of the words that I said was suspicious. There's another one of your police loopholes right there, the word suspicious. Okay, so going back to the eponymous now, McLean, 113 California 452, the word operator shall not include any person, listen now, the word operator shall not include any person who solely transports his own property and who transports no persons or property for hire or compensation. Statutes at Large, California Chapter 412, page 833, the right of a citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty, and pursuit of happiness. The very first part of that case is the part that I'm getting at. When the police officers ask you, did I not just witness you operating your motor vehicle? Nope. I'm not driving in commerce. Supreme Court has defied the word operator and specifically stated in its finding that an operator is not someone who is not moving property or cargo or people on the highways for hire. Okay, so that's not what an operator is. An operator is someone who is doing that for compensation, for hire. So that right there, that's these are some of the master constitutional case laws. Okay, these are the master cases that come from the Supreme Court. These cases here are not, and when I tell you this, these are not altered case laws. These are not, they fit someone else's agenda. Nope, not these. These are the real deals, straight from the books. And that's what I always try to tell you guys when you are posting case law, to go read the cases. Go to the library. Don't go online and read case law. Go to the law library. Get it out of the books. You'd be doing yourself a big favor and relieving yourself from a lot of headache and stress as to the validity of whether or not that case is legit or not. If you're getting it straight out the law book, it's legit. You feel me? If you're getting it straight out the law book, it's legit. You can't dispute it. It's in the law book. Okay? And the law books, they have many. So get your information from the law books. And you know, if you can cross-reference it online and find out that it collaborates. Now they do have some good online sites, law sites. Law Finder is one that I come to rely on a lot. Justica I rely on a lot. Uh, you know, they actually have unaltered cases, you know, in there. So the best thing, you know, but like I said, your best option, man, is just to go to a law library and research the cases, because it'd just do you a whole lot better. So anyway, we're going to continue on with what we were doing from part one. We're going to pick up where I left off. So we're going to get right into it. And let's see, where are we at here? Okay, so if confronted by an officer, you are likely to get a ticket for not having a social contract. You can explain it's your right, but it is still at the officer's discretion. There you go again, another loophole. If an officer does issue a ticket, then they enter into a commercial field of activity. If you remember when I was telling you earlier, I mentioned something about the traffic ticket is commercial. A lot of people don't even know that, and you're going to learn that. So this makes them liable to be sued for violation of their oath. Listen now. When the government entered into a commercial field of activity, it left immunity behind. Land versus Dollar, 338 U.S. 731, 1947. It is clear that when the police enforce a license on private owners, they knowingly violate their oath, Article 6, did you hear that? And your rights, Fourth Amendment, by enforcing of a contract, Article 1, Section 10, Paragraph 1. With regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. Shuttlesworth versus Birmingham, 394 U.S. Dun dun dun. Well, there you go. Look at that. Getting into some meat and potatoes now, people. Getting into some good meat and potatoes, and I need a little bit of gravy. As a matter of fact, I want some of that milk gravy. Yeah, I need to have some of that good old milk gravy on my potatoes. To include going beyond their authority when restraining a citizen without a warrant, even for the purpose of requiring them to identify themselves. When officers detained defendant for the purpose of requiring him to identify himself, they performed a seizure of his person, subject to the requirements of the Fourth Amendment, Brown versus Texas, 443 U.S. at 47. It must be recognized that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. Terry versus Ohio, 392 U.S. 116, 1968. When citizens continue to allow law enforcement to encroach laws made by government commercial corporates upon the private citizens, then we have submit to law enforcement's violating their oath to monopolize the liberties. It is the duty of the citizen to sue any public official when they continue to violate their oaths. And see, basically what they're saying is it's all about the oath, because they took an oath to uphold the Constitution. So therefore, any violation of your rights is a violation of the Constitution. And if you stand on the Constitution, then you defend the Constitution by suing them for being traitors. There you go. Traitors of the Constitution. Treason. So there's that. And that was, yeah, I was punching that out there to all you constitutional traitors, haters, and you know, you guys, you know. So complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet the highways may be completely monopolized. If through lack of interest the people submit, then they may look to see the most sacred of their liberties taken from them one by one. by more or less rapid encroachment. Robinson versus Department of Public Works, 108, 180 Washington, 133 to 147. The right to travel is protected by the Equal Protection Clause of the 14th Amendment. Right to travel is constitutionally protected against private as well as public encroachment. Zobel versus Williams, 457. U.S. An administrative regulation, of course, is not a statute. U.S. versus Mirsky, 1960, 361 U.S. Article 6 requires all public officials loyalty is first to the Constitution, then to their duties. When government corporates violate their oath to make laws against the Constitution, the Constitution then use law enforcement to violate their oath to enforce them, requires the officer to choose between oath and duty. Any law that is repugnant in conflict with to the Constitution is null and void. Marbury versus Madison, 5 U.S. If law enforcement want the people's trust and respect, they need to know the difference between privileges and rights. They must understand that enforcing the law is not a requirement, but a discretion. There's that word, discretion, loophole. Government commercial corporates included this clause as a loophole to allow law enforcement from violating their oath when confronting a non-bonded citizen. Confrontations between citizen and law enforcement can be avoided when an officer knows the limits of their authority. An officer who acts in violation of the Constitution ceases to represent the government. Nebbia versus New York, 291 U.S. So, this is a plea to all that take the oath to protect the people. Don't let the government commercial corporates force you to violate your oath to encroach their contracts upon the citizens. Their contracts are a deception to enslave the freedoms of all citizens. You have the discretion, you must decide, oath or duty. Oath violators take rights away from those the law does not apply. To include freedoms the Constitution guaranteed them. Think before acting. In other words, that's kind of like a note to the police letting them know, hey, oath or duty, So, courts, lawyers, and jurisdiction. This topic refers to all courts, traffic, tax, drug, etc. Courts were organized as a corporate incorporate. These courts are based upon amorality maritime law. This means that they are laws of the sea and coastal. These laws can only be bought on land by contract. These courts do not deal with justice or rights, but with contract disputes. Interesting. License is a contract, so makes sense. Okay, so let's see where I'm at. Okay. When a city is formed and incorporated in a state, the city forms an incorporate and a municipal court to handle city disputes, which is true. Their jurisdiction is also linked to contracts within their city limits. These courts are known as amorality maritime courts. His rights are such as existed by the law of the land, long antecedent to the organization corporation of the state. Hale versus Henkel. Henkel. Yeah, 201 U.S. 1905. That's that case that I read earlier that was letting you know that 1905, 1906 when that case was actually decided. That case has been back and forth to the Supreme Court 1,600 times, and not once has it ever been overturned. Amorality maritime courts only purpose is to settle disputes between two parties regarding the contract. Without a contract, DMV, 1040, etc., the court has no jurisdiction. Courts can't acquire jurisdiction thinking they have it. Understand, if you do not challenge the basis of jurisdiction, the courts will proceed without addressing your objection. This is where courts acquire jurisdiction over your case. So, meaning, if you don't walk into courts, like I was telling you before, if you don't walk in there and challenge jurisdiction, they're going to assume jurisdiction by your having not objected to jurisdiction, and that's how they gain jurisdiction, by your failure to, object to jurisdiction. So you always want to make sure that that's the first thing you do when you walk in that courtroom, is challenge jurisdiction, as I was telling you earlier. Okay? However, according to law, when the question of jurisdiction is placed before any court, it must be physically produced by the court. Not you, the court. A court cannot satisfy it by mere want. Okay? Industrial Edition Association versus C1R, or CIR, my bad, 323 U.S. 310 313, where there is no jurisdiction, there is no judge. The proceeding is as nothing. Bradley versus Fisher, 80 U.S. 13 Wall. Driving is a right. Driving is a right. How many of you have been programmed to believe that driving is a privilege? So why plead guilty to your rights? People fear the impounding of their automobile or be arrested if caught without a license. The problem lies when officers think they have that authority. If the officer acts to do so, they commit color of law by stepping over their authority and violating their oath. A citizen can pursue charges against the officer for damages. Public officials are not immune from suit when they transcend their authority by evading constitutional rights. Afflico versus Woodward, 406. If a prosecutor must prove you violated a contract, you ask, why do people that do not have a contract lose in court? Through deception. What was I saying? You're going to be deceived. You're going to be deceptive. The loopholes. So through deception, that's how you're going to get beat. Example: the DMV statutes claim you're required a license, and through admittance that you don't have a license, it appears that you violated their law. Now, if you don't have a license, how can you violate a contract? It is through deception that you was required this contract and not claiming the validity of your rights not to have that contract. Only commercial are required DMV contracts. Party cannot be bound by contract that he has not made or authorized. Alexander versus Bosworth, 26, California. So that's, again, I was telling you, you have to challenge jurisdiction. If you don't have a contract with the DMV or the DOL, okay, challenge jurisdiction, because you have a right to consent to contract. You see what I'm saying? The state does not have a right to force you into contract. You can't be forced to contract. See, that's where the courts, where they always win these cases, is because nobody goes in there and challenges jurisdiction. The bottom line is you challenge jurisdiction, period. And you have the supporting case law sitting right there with you. You know, as long as you can challenge that and get them to prove that they have jurisdiction over you, because here's the thing, you should have affidavits, okay, affidavits of truth supporting that. If they should happen to come up with your name and an old address, okay, you have affidavit. You should have already researched this before you've even gone into the court. So what you need to do basically is you need to go research and find out if your name exists in any database where you're under a last known address, is basically what I'm looking for. So, and if you see that, you write an affidavit to the effect of that address, or that information, and you get it notarized, and you put it, and you make that affidavit as an affidavit of fact and truth. Because once you do that, you establish your grounds for exhibits to show that you don't reside at that address. You see what I'm saying? So therefore, it does not, that still eliminates the state from having or obtaining jurisdiction over you. See, always have a little backup plan. So your backup plan is to make sure that you do an affidavit of truth and affidavit of facts. You can do them both on the exact same deal, affidavit of facts and truth. You know, and put that information in there, get it notarized, boom, it's legal. It's a legal document. Okay, so a lawyer is an officer of the courts. They are licensed to practice law. A lawyer works for the legality of the courts. Legality of the courts, not you. You lose your rights when hiring a lawyer because it puts you under the court's jurisdiction. A lot of people didn't know that. Only you can claim your rights to jurisdiction. Rights cannot be claimed by attorneys or solicitors. It is valid only when insisted upon by a belligerent claimant in person. McAllister versus Hinkle, 201 U.S. 90. And that's funny because that's the same Hinkle that the case came around that was Haynes versus Hinkle. That's the same Hinkle coming out of the 201. For anyone to have jurisdiction over another, it requires a contract between two parties. To acquire jurisdiction is kidnapping. If a court knowingly proceeds without jurisdiction, it is a treasonous act. There is no justice in a monopolized court, and there is no rights in a contract court. Treasonous acts against a non-bonded citizen: if you don't have a DMV license contract and your car is impounded, then it's stolen. Arrested, then you have been kidnapped. Given bail, then it is a corporate ransom demand. The most organized criminal enterprise to ever walk on the face of the planet is the U.S. government. Just in case you're wondering. How treason is committed. Government commercial corporates use deception in the requirement of contracts. Law enforcement are used to threaten you into the contract, and Admiralty Maritime Courts use contracts for jurisdiction. They know that if you are without a contract, the government or courts have no jurisdiction. Judges are corrupted by committing treasonous acts for knowingly allowing cases to proceed without jurisdiction. 70 to 80% of all cases and individuals incarcerated in jails and prisons have been falsely accused by a fictitious corporate crime. Immunity for judges does not extend to the acts which are clearly outside of their jurisdiction. Bowers versus Heiss, CA, NJ, 1966. Let's see. The first thing any citizen should do in any court is demand the courts prove jurisdiction. See, I was just saying that. I was just telling y'all that. Demand jurisdiction right away. First thing. Most cases will be dismissed if you don't have a contract with the government corporate suing you. DMV, IRS, federal, etc. You win. Bottom line, you'll win. If any tribunal court finds absence of proof of jurisdiction over a person and subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. Louisville versus Motley, 2111 U.S. So there you go. The accuser bears the burden of proof to prove that they have jurisdiction over you. Not the accused, the accuser. Okay? And just like I said, keep in mind, you have to exert your authority, which is actually the next topic that we're going into. You have to exert your authority for jurisdiction. So you always want to make sure that the very first thing you do before the court proceeding even progresses along, challenge jurisdiction. Now I've seen where a lot of people would challenge jurisdiction and the courts would ignore them. You know, you cannot allow for the courts to ignore you. You continuously state on that case, I challenge jurisdiction. And I've seen where the courts find people in contempt, obstruction of justice. They all, they use these terms, as I told you, they use these expressions to dissuade you. Don't be feared. It is your constitutional right. So you have a right to confront the court. You have a right to challenge its proceeding. And one of the things you always want to make sure you challenge is jurisdiction. Period. End of story. Just challenge the jurisdiction, people. Promise you, the outcome will be so much better. So, authority. When officers or courts act beyond their authority against your rights, then they violate U.S.C. Title 18, Section 241, 242, Code of Law. All corporates can be sued. Any citizen that is falsely accused without a contract is obligated to sue these corporates to stop future harassment. If you don't sue, the harassment will continue. Deprivations of rights under color of law, 18 U.S.C. 242. This provision makes it a crime for a person acting under color of law, of any law, to willfully deprive a person of a right or a privilege protected by the Constitution or laws of the United States. Judges not only can be sued over their official acts, but could be held liable for conjunctive and declaratory relief and attorney's fees. The Zuma versus Justice Court, AO 25829. Judge acted in the face of clearly valid statutes or case law expressly depriving him of personal jurisdiction will be held liable. In such case, the judge has lost his judicial function, has become a mere private person, and is liable as a trespasser for damages resulting from his unauthorized acts. Dukes versus Hosman, 743. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. Owen versus the City, 445 U.S. Officers of the court have no immunity when violating a constitutional right from liability, for they are deemed to know the law. Owen versus Independence. And that 100 SCT. So there you go. Ignorance of the law, no excuse. That's basically what that's saying. Corporate governments may make laws that violate their oath. Doesn't mean that they have the authority to do so. Law enforcement may think they have the authority to enforce it upon everyone, even if they violate constitutional rights, do not apply to the citizens without contracts, or violate an officer's oath. Law enforcement must decide to choose between oath or orders, and they are not required to enforce a law which will violate their oath. When confronted with non-bonded citizens, they have the authority of discretion. If enforced, they enter a commercial field of activity, which makes them liable for lawsuits for unauthorized actions under color of law and oath violation. Actions by state officers and employees may, even if unauthorized or an excessive authority, can be actions under color of law. Stringer versus Dilger, California 10, 1963. Rules, regulations, statute, codes, and laws. Here you go, people. Getting into the good stuff like I told you. This is about the loopholes. So, the purpose of loopholes in rules, regulations, statutes, codes, laws is to keep from violating your constitutional rights. The government only has the power to form and regulate corporations. They have no power over the corporate business. The state uses the corporates to indirectly control the people's constitutional rights. They allow corporates to contract citizens, then regulate how the corporates do business. To clarify, court cases did state, for the safety of the public's interest, the state has the right to enforce regulations. Courts failed to explain that the state regulations does not include a driver's license, registration, or insurance regulated by the DMV, but road regulations regulated by the state, such as safety, caution, traffic lights, speed limits, traffic signs, etc. And that's what I've been telling you guys from day one. The regulations had nothing to do with a license, registration, or anything of that magnitude. I've been telling you all that. And this is coming straight out of a case. You know, Chicago Coach Company versus the City of Chicago. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways transporting his vehicles and personal property for either recreation or business, but by being subjected only to local regulation, safety, caution, traffic lights, speed limits, etc. And this is not an altered version of that case, because there is an altered version out there. This is the actual case, what is cited in the case, word for word. Go look it up. I just gave you the citing. Each citizen has the absolute right to choose for himself the mode of conveyance he desires, whether it be by wagon or carriage, each citizen has the absolute right to choose for himself the mode of conveyance he desires, whether it be by wagon or carriage, by horse, motor, or electric car, or by bicycle, or astride of a horse, subject to the sole condition that he will observe all those requirements that are known as the laws of the road. Cumberland Telephone and Telegraph Company versus Yeaser, 141 Kentucky. And when they say laws of the road, again, they're not talking about license and registration. That's not a law of the road. Law of the road is the speed limits, traffic lights, stop signs, etc., etc. The signs that you see, the traffic signs that you see on the side of the road. As long as you're in compliance with those, that's all you're required to do. You know, it's pretty clear cut and dry. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. Police have the right to ticket, listen now, you for violation of road regulations, but have no authority to enforce a license, a registration, or insurance contracts on private automobiles. Remember when I was telling you at the beginning of this video, in part one, I was going into the explanation about safe operation of your automobile, and that, you know, the road laws apply. When I was referring to a video where the gentleman in the video didn't think that the traffic laws applied to him, because even though he was driving without license, traveling without license and registration on his car and plates, etc., he was doing 85 and a 65 or something to that magnitude, speeding, and he got pulled over and was given a ticket. But he wanted to argue with the officer, talking about those regulations don't apply. Yeah, they do. They do apply. And they should apply to everyone. I don't care if you are out there traveling without a license and, you know, your car's not registered, you don't have plates on your car. You don't deserve a ticket for that. But if you're breaking the laws of the road, then you subject yourself to cross over into their jurisdiction. Just like there's consequences when you accept the privilege, there is consequences when you accept the travel in the private. So you got to keep that in mind, because the line that you cross being private is so nil and thin that you'll cross over into their jurisdiction without even realizing. Traveling down the road, speeding, you get a ticket. You just crossed over into their jurisdiction, and there ain't nothing you can do about it, because of the simple fact is you did break the law. So that is something that's going to have to be worked out amongst the government as to how they want to go about executing that type of, safety measure. Because, as we all know, traffic tickets are commercial, because they're issued for people doing commerce, driving in commerce. So everything that comes out the DMV, the DOL, the DOT, and all that is all commercial. We all know that already. It's been established. Reno versus Condon established that and made it very clear that anything dealing with the DMV, the DOL, is commercial. So we don't even have to sit here and go back and forth and bicker about that, because the state is allowed to regulate its activity, its business, and its business is commerce. So yeah, you can regulate that, but if I'm not doing commerce, and we all know that commerce means trade, business, so if I'm not doing commerce, I'm allowed to travel. And how that got crossed, who knows. But anyway, back to this, So, no authority to enforce a license, registration, or insurance contracts on that of private automobiles. You must understand your constitutional rights are protected, but if you impair yourself, which will cause danger to another person or their personal effects, makes you liable for your actions. Ignorance of the law does not excuse misconduct in anyone, least of all in a sworn officer of the law. McCowan, 1917, 177C, 93. Now, here's the thing. All my brothers and sisters out there traveling and doing what we're doing, I don't want to hear the bullshit and y'all talking about why I gotta be held accountable. I don't want to hear that shit, because that's bullshit. That's not a one-way street. You want to hold the police accountable, you make sure that if you violate the law and you do something wrong, you hold yourself accountable. Because that's how that works. That's a fair assessment, I would say, that if you go and you speed and you get a ticket, be accountable. Stand up and be accountable. Because I'm going to tell you right now, by being accountable, that makes our fight a whole lot better. And it shows that we accept far more and better responsibility for our actions than those privileged individuals. And never in life has it ever been established that by you acquiring a driver's license and registration on your automobile, that it reduced the risks of accidents and fatalities on the highways. You can't ever prove that. As a matter of fact, if you really want to go by what the statistics say, the statistics actually won't go to the state's favor in an argument. So you don't ever have to worry about that, because it'll never go to the state's favor. Because as I told you in one video before, I actually pulled the statistics up for the state of Washington, and out of 3,900 and something odd fatalities that occurred during a certain span of time, 13% of those fatalities was caused by non-licensed drivers. The rest were all privileged drivers. So yeah, that safety argument for the state fails. 100% fails. But anyway, that's neither here nor there. It's another story for another time. Contracts. Governments are a corporate entity. Corporates are commercial. Their laws only apply to their commercial contracts. They have no jurisdiction over your actions without a contract. For their laws to be valid, to take away your freedom requires a contract. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his door to an investigation, so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom. Beyond the protection of his life and property, his rights are such as existed by the laws of the land, long antecedent to the organization, corporation of the state. He owes nothing to the public so long as he does not trespass upon their rights. Hale versus Henco, 201 U.S. So there again, there it was. I said Haynes earlier, but it's Hale versus Henco. Any government corporate making laws to ban assault weapons require federal background checks or concealed weapons permits, etc. Again, these laws only apply to those contracted to that entity. Party cannot be bound by contract that he has not made and or authorized. Alexander versus Bosworth. Okay, so a gun business owner's misunderstanding. When a gun business requires a non-bonded citizen to submit to a background check, he has infringed on that citizen's rights. A gun business can only require the submission of those contracted to that government corporate entity to submit a background check. Government corporate entities have no jurisdiction to force gun businesses. Hope y'all listen to this, because this is what y'all need to know. Gun businesses to infringe on non-bonded citizens' rights. The same goes for concealed gun permits and banning of weapons of those contracted to that entity. The government corporates only see the Constitution as a contract between the corporate and the citizens because they claim the Constitution is not absolute. They added additional amendments to manipulate and alter the Constitution to their advantage. Corporates used the Admiralty and Maritime Courts to uphold their treasonous laws. Changing the Constitution made it null and void. Well. Deception. When a government corporate entity makes statutes, laws that does not clearly identify their true meaning, loopholes in the laws, and use deception to deceive a person into their contract, makes these contracts null and void. Chief Justice Marshall's unanimous opinion can be interpreted to state that withholding information that is calculated to deceive the other party can cause a contract to be void on equitable grounds. Laidlaw versus Oregon, 15 U.S. Imagine that. Boy. Getting into some good stuff, y'all. But, unfortunately, as you can see, the time has ran away from us. So, what I'm going to do is, I'm going to go ahead and call this the end of part 2. And we'll pick it up in part 3. And we got a ways to go yet. So, like I said, there's a whole lot that I got to share with you guys about this. You know what I'm saying? So, just it's time to be in the know. So I'm going to try to keep you guys in the know. And I know all you haters, traitors, and all that. Haters, traitors, and haters. Damn, you know what I mean. You guys, trolls, yeah. You trolls, haters, and traitors, you guys hate this. Because here's the thing, you guys can sit there and try to conflict with what I'm saying, but you can't contradict what I'm saying. You have nothing. You have no case law support. And I just showed you that your favorite case, the Hendrick versus Maryland case, what it says about operators and drivers. The motor vehicle code is commercial, and that's what that case was in reference to. It's all commercial. So there you go. You can quit referring back to that Hendrick versus Maryland case, because here's the thing. You have to understand something. If that case was justified as being the standard to the regulation that you guys believe that it is, why isn't it ever being used against us? It's not. That case has never been used against us in any argument. That should give you some food for thought, because that case, even though it did set precedents for certain parts of a regulation, it has no power. That case never had power because of the simple fact it, like all the other cases that was ever surrendered from the Supreme Court, was in reference to commerce, commercial activity. And even though Hendricks was not utilizing his automobile for commercial activity, which actually it even says in there, it has never been established as to whether or not he was or not, the bottom line was the judge referred to the act of commerce in general, the overall act. And commerce is commercial. So there's that. So anyway, as I said, we're going to go ahead and close this one out. This is part 2 in the books. Part 2. One country, 2 jurisdictions. What the government does not want you to know. This is Dark Angel. Deuces.